All right, I'll allow that to proceed in this way. And she was going to pay 159 by the 29th of May.
Welcome back to Trial Truth, where real courtroom moments turn into masterclasses in justice, irony, and emotion. Today's case pits Group 5 management against Olivia Bell, a tenant caught in a storm over pet fees, service animals, and one very misunderstood Chihuahua. From a pit bull eviction to emotional support paperwork wars, this one's a roller coaster of technicalities and tension. Judge Simpson, sharp as ever, isn't letting confusion slide today. He's about to question whether landlords truly understand emotional support laws or just use them as billing loopholes. As the courtroom dives into rent subsidies, missing doctor notes, and the mystery of a violent pit bull turned Chihuahua, things get wild. Stick around, because when service animals become legal battlegrounds, it's never just about the dog. It's about power, rights, and proof.
Did that get done, Mr. Weiss?
We did get a payment of 159 on May 3rd. We posted on May 30th, yes.
Okay, fantastic. That was one of the things that was supposed to happen.
Yeah.
Returned out to today. What do you have as a current balance?
Okay. The amount we're showing is $1,054. It's comprised of a pet deposit fee, a $25 pet fee per month going back to October 2023. Late fees of $325 and NSF fee of $60 plus court costs.
Okay. So in that, I did not hear rent.
No, she's well,
She's fully subsidized.
She paid the $159 is her portion of the rent.
That's why we had that paid. Okay.
Yeah.
Okay, so let me ask this.
Like
So why was the
Oh, I guess so. Did you get the I'm sorry.
I did, but I mean, we'd have to discuss the account.
Okay,
So,
I'll call back.
Busy right now, having.
Thank you. Sorry, Your Honor, I was on another call.
all right. So I got 9 months of a pet fee.
Correct. It's in the lease.
Okay, it's in the lease, but my question is why am I dealing with it 9 months later?
Well, they were going back and forth as to whether or not this was an ESA animal. And she did not provide this is a second dog. The first one had to be removed because it was deemed violent. It bit another tenant. So she got another dog.
And there it is, the moment that changes everything. A dog bite transforms a housing dispute into a legal gray zone. Once that first pit bull was removed, the question became, does Olivia still qualify for an emotional support animal without reapplying? The landlord argues yes, new dog, new paperwork. But Judge Simpson's body language says otherwise. Under Fair Housing Act rules, the right to an emotional support animal is tied to the person's need, not the pet's breed. You can replace a dog, not the disability. It's not about aggression or breed. It's about medical validation. Still, the optics? A pit bull bites someone, and now there's a Chihuahua in the mix. You can feel the tension in the room shift. Everyone's wondering, does compassion have conditions?
We asked her to comply with the ESA requirements back in October, and she has failed to do that. So that's why the pet fee of $225, there is a pet addendum to the lease. It's $25 a month plus a $200 pet deposit that she does owe. And it's deemed, rent for the lease.
So when did the first dog qualify?
The first
Yes.
dog qualified. It was
So then it was removed.
because it was a pit bull and it bit somebody. But the
Okay,
dog,
okay. All right, hold on. Okay, so that dog had to be removed. She gets another dog.
Correct. And that dog would have to qualify the same way as an ESA with the doctor's statement.
Judge Simpson is laser-focused here, dissecting the landlord's reasoning like a legal surgeon. The landlord keeps saying the new dog must qualify, but the judge knows that's legally meaningless. A dog doesn't qualify, a person does. This subtle but crucial difference determines everything. If housing policy treats emotional support animals like optional pets, it risks violating disability accommodation laws. Olivia's need for support doesn't reset just because she changed dogs. What matters is whether she still requires that support, something her doctor already certified years ago. You can almost hear the frustration in Simpson's tone as he tries to steer the landlord toward the real issue: policy versus principle. This is one of those exchanges where the judge becomes both teacher and referee.
That is necessary and required. She has failed
Hold
to.
it, but here's what I'm trying to figure out. The doctor's statement had no bearing on the dog itself. It was as to Miss Bell, right? Is that right?
What?
Meaning, whether I got a Chihuahua or a Burmese mountain dog, doesn't matter what the dog is. It's just that Miss Bell needed the dog.
At that time, the first dog, yes. The question
Right.
is,
So hold on a second, Mr. Weiss. This is what I'm not understanding. That dog she has to get rid of, whatever the reason, doesn't matter. There then is a new dog that she gets. So my question is, other than the qualification of the dog, why would you need something new if it's the person who needed the dog?
okay, let me see if I can explain it to you, Your Honor. Miss Bell's been there for a while. She had a heart condition back in 2017. She got the pit bull. She got the qualification for ESA, so there was no pet fee or pet deposit.
Correct.
Our policy is for any new dog, there would have to be the same justification. So she got a new dog, I think sometime in 2023. That dog would have to qualify.
But hold on a second. You're not, as I understand what you're doing as a landlord, you're not qualifying the dog.
No, but the question is, since
No, hold on though. What you're doing is you're not qualifying the dog, you're qualifying the person to have the service animal.
well, what we're saying, Your Honor, is that at the time of the new dog, she would have to qualify again as the need of the dog. That was 6, 7 years ago. How do we know that she still does need the dog? And her doctor refused to send in that qualification. Had that doctor sent in the qualification and filed the proper paperwork, yeah, we would have done it. But that doctor refused to do it. That's why we're here. I understand your problem, Your Honor.
Oh, my issue with that is if it's about the person, then why does it change when the dog changes?
Well,
It would seem to me that you would make her qualify every year, 2 years by having the doctor's notes and then to make sure that she still needs the dog.
not necessarily, Your Honor. At the time that the original, hang on, Your Honor. At the time of the first instance, she would have to qualify, and the dog would have to qualify. But
No,
the
but what's not, the
circumstances
dog
may have
isn't
changed.
qualifying. You are not qualifying the dog.
Yeah,
I could go get any dog in the world, bring the dog there, as long as her doctor says she needs a service animal, you will then qualify her to have a service animal.
But her
She's the no, Mr. Weiss. You're qualifying the tenant to have a service animal.
correct.
The
Okay.
service animal itself, in a lot of ways, doesn't matter. She
Correct.
could have had a service dog. She could have had a service turtle. That's what I'm gonna have. I'm gonna get a service turtle. Anyway,
This is peak courtroom humor. Judge Simpson jokes about a service turtle, but the humor masks a deep truth. Service animals come in all forms, and the law doesn't discriminate by species. What matters is whether the human has a verified emotional or physical need. The laughter diffuses tension, but it also exposes how absurdly technical these disputes can get. Olivia's Chihuahua might seem trivial compared to a pit bull, yet both serve the same legal role if her doctor says she needs one. This moment shows Simpson's brilliance. He uses wit to reset the room and remind everyone of the real issue: compliance, not control. Viewers, what's the most ridiculous emotional support animal you've ever heard of? Comment below. We're betting none beat a service turtle.
Right.
she could have whatever, as long as a doctor is saying this is what this person needs. So if the issue really was, once the dog no longer could be there, if the issue then was that it's the dog itself, then I could see that argument if she would have to qualify as being in need of a service animal every year. But she doesn't have to do that.
No.
She would be qualified as long as that other dog lived.
Okay, that is correct. However, if the dog is no longer there, we would need justification from the doctor that she still needs a service animal.
Yeah, but hold on. She didn't. Why? If that dog had stayed there, she
Yes.
wouldn't need to do anything.
Correct. However, since the dog is no longer there, she would have to
She
establish.
brought a substitute dog in.
Okay. She brought a substitute dog in.
Yeah, the other
However-
dog's on vacation. Why? What? I don't. That doesn't make any sense, Mr. Weiss.
Oh, I
It
think it
just
does.
doesn't.
I think it does.
I don't get it. If it's her qualifying, she's qualified to be in need of a service animal. Until somebody says that changes, she's still qualified in need of a service animal.
Correct.
The one service animal something happens with, she gets a new service animal. I think it's going to be up to plaintiff to prove she's no longer in need. And
No,
I don't think you're going to be able to do that. And I don't think you can under your lease because she automatically qualifies, or she doesn't automatically qualify. She qualifies and she stays qualified to have a service animal.
see, that's where you and I disagree.
This back and forth is pure courtroom chess. Judge Simpson is drawing a line in the sand. Qualification doesn't expire. The landlord argues that Olivia must reprove her disability need each time she gets a new dog. Simpson counters that unless there's evidence her medical condition changed, her qualification stands. This is a powerful legal precedent. Housing rights are based on consistency, not convenience. What makes this moment even more compelling is Simpson's calm authority. He's not emotional, he's logical, grounding his reasoning in both fairness and statute. It's one of those instances where you realize courtroom drama isn't about shouting, it's about precision. If you've ever dealt with confusing housing policies, this exchange probably hits home.
I think at the time, I agree with you to the extent that if the dog had still stayed there, she qualified back in 2017. Okay, the dog's no longer there. How do we know she's still, when she gets a replacement or a new dog, how do we know she still needs a service animal? That's why
We'll put the dog on the stand.
the dog uses sign language.
Remember that? No, that's okay. Depending on what kind of dog it is, I can talk to it. We'll have it testify.
I wondered about that, Your Honor. But what we're saying is that why, just out of curiosity, why wouldn't the doctor certify that she still needs the service animal? That's where we are.
Oh, I cannot answer for a doctor and I'm not going to.
No, and the doctor hasn't answered or filled out the
He
form.
may have said,
She
why
doesn't
am I
need to.
doing this? She's already been qualified to be the service animal. Well, I'm not signing another thing. You have no basis upon which to ask.
She never said.
That might be the reason.
Doctor never said that. She says,
But I don't know that. All right. So how much are these pet fees? How much of this amount that she owes is a pet fee?
She owes, looks like $425, including the pet deposit.
Okay, so $425 of what she owes is that.
Yes.
What's the other? Is it a late fee because she didn't pay that?
In part, and there were 2 NSF fees totaling $60 and the court costs.
Okay, so the NSF fee she might need to pay. I don't know about those court costs. We'll have to figure that out because the bulk of what she's brought here for are not paying the pet fees.
Now the case hits its core. Everything circles back to those pet fees. Judge Simpson makes it clear the unpaid amount isn't rent, it's administrative add-ons. That's critical because eviction law treats unpaid rent differently from unpaid extras. Olivia's facing court not because she defaulted on rent, but because she didn't pay fees tied to a legal dispute over her dog. This flips the narrative. She's not a negligent tenant. She's a confused one caught in policy overreach. Simpson's patience here shows restraint. Rather than punishing her, he wants clarity. Should a disabled tenant really face eviction for a fee her doctor's office didn't confirm? That question lingers heavy in the air.
And for not paying the pet fees and then the late fees that are incumbent upon that. All right. So
if you want to,
when do we want to have a trial?
What?
When do we want to have a trial? I'm ready to try it.
I
mean, because this is going to be easy. Somebody's going to have to come in and explain to me why she has to pay these fees again.
Well, why don't you set it? You want me to bring the doctor and subpoena the doctor?
You can subpoena the doctor if that's what you want. I don't know that the privilege is going to be waived, but that's okay.
What's your pleasure, Your Honor?
Well, when can we try this?
You want to do it on a Friday?
No. Just
No.
had to mess up Friday. We'll do it on Tuesday.
There's July 16th at 9 a.m.
July 16th at 9 a.m. in person.
Thank you, sir.
July
He's gonna get
16th.
the doctor. Is that what he said?
What
July
time?
16th, 2024. At what time?
9 a.m.
What time, mate? What time? Emily?
9 a.m.
Can we do it a little bit later? I have a court hearing in Davis. We do it like 10:30?
10 o'clock.
10 o'clock?
10 a.m. 10 a.m. on the 16th.
Okay.
All right.
All right.
What kind of dog is it?
A Chihuahua.
You have it's a Chihuahua?
A Chihuahua. I had a pit bull at first, and
So now you have a Chihuahua.
a Chihuahua, and all he do was stay in the house. All she does stay in the house with me and bark, 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 bark.
The doctor authorized her to
No, I'm good. I'm good. Thank you, though.
All right.
And there it is. The tension dissolves in laughter. A Chihuahua compared to the Taco Bell dog brings this tense hearing to a strangely human close. But beneath the humor lies a sobering truth. This case wasn't about dogs. It was about the limits of understanding between landlords, tenants, and medical verification. Judge Simpson handled it with empathy and precision, reminding everyone that housing law is meant to protect dignity, not punish paperwork errors. Olivia Bell's case spotlights a growing issue in tenant rights, how emotional support animals often become collateral in bureaucratic confusion. Whether the Chihuahua stays or not, Simpson's logic leaves no doubt. Need outweighs nuisance. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.